Good evening, ladies and gentlemen. My name is Stacey Primshaw, and you're watching Medical Malpractice. The laws, policies, and social effects surrounding wrongful birth will be explored before deliberations into reform will be examined.
In civil law, the tort of negligence has three elements: a duty of care, a breach of that duty, and resulting in damage that is not too remote. An action brought by the parents of a healthy child seeking damages for the birth of an unintended child is known as wrongful birth. Damages claimed include the costs of the child's upbringing. The basis of such an action is usually failed sterilisation, but the action could also be brought by the parents of an impaired child, alleging negligence by the medical practitioner in failing to advise them properly and thus denying them the chance to abort the fetus. Unlike a wrongful life claim, the action attracted some sympathy in Australia and had success in the High Court in Cadanac and Melchior. Legislative response was swift, and the amount of damages available in wrongful birth is now limited under the Civil Liability Act 2003, Section 49A and Section 49B. In this jurisdiction, damages to cover ordinary costs of raising a child are unavailable. The duty of care relationship relative to wrongful birth is that of a medical practitioner and patient. A medical practitioner is defined as a person who is registered under Australian law in the medical profession. The relationship between a medical practitioner and patient is one of the oldest categories recognised as a duty of care. In the case of Sidaway and Bentham Royal Hospital, it was discussed by Lord Justice Diplock that a medical practitioner has a single comprehensive duty covering all the ways in which they are called upon to exercise their skill and judgment. Within wrongful birth, there are many duties in which a medical practitioner owes a reasonable care to a patient, those of which may include duties regarding informed consent, duties regarding treatment, duties to non-patients and third parties, duties to disclose error, and vicarious liability and non-delegable duties.
In the context of medical liability, a discussion of vicarious liability and non-delegable duties arises most often when it is necessary to determine the circumstances in which a hospital will be liable for the negligent acts of a medical practitioner. In accordance with principles of vicarious liability, an employer, such as a hospital, will be held liable for any acts of an employee done in the course of their employment. It is in these circumstances that the liability of a hospital may extend beyond vicarious liability to a non-delegable duty to its clients. Just as these duties exist, they also have the ability to be breached, in which a claim to the courts may then occur. Breaches of duties occur when a particular duty of care has not been fulfilled, therefore causing damage to the patient. As mentioned in the Bolam case, a doctor is not guilty of negligence if he has acted in accordance with a practice accepted as proper by a reasonable body of medical men skilled in that art. This was called the Bolam test and was officiated as the test for standard of care in the breach of duty for medical liability in Australia. However, this was more recently overturned in Rogers and Whittaker that decided the Bolam test was no longer applicable. Rogers and Whittaker remains the leading case for informed consent in Australia and is the test that decides a patient should be informed of material risk if, in the circumstances of the case, a reasonable person in the plaintiff's position, if warned of the risk, would be likely to attach significance to it, or if the medical practitioner is or should be reasonably aware that that particular patient, if warned of the risk, would be likely to attach significance to it. Within the Civil Liability Act, there are specific provisions which mentions the general principles regarding breach of duty. Section 9 speaks particularly about the standard of care and risk factors, then also sets out the factors to evaluate the reasonableness of the defendant's response, which includes the probability of harm, likely seriousness of the harm, burden of taking precaution to avoid the risk of harm, and social utility of the activity. This process from Section 9 becomes a question of fact for the jury to then decide whether a standard of care has been breached. They then consider the degree and gravity of the risk balanced against the practicability of the precautions, utility of acting, and consideration of professional to decide this. There are explicit provisions which address the breach of duty to warn. More specifically, Section 21 establishes a proactive and reactive duty of doctors to warn of risk. It is within this section that there is no breach of duty by a doctor to warn of risk unless the doctor fails to adequately inform the patient about the risk in line with the legislation. A breach of duty in treatment is also found within the Civil Liability Act under Section 22, which focuses upon the standard of care for professionals and provides that there is no breach from the provision of professional services if the professional acted in a way that was widely accepted by peer professional opinion by a significant number of other respected practitioners in the field. Additionally, there can be more than one widely accepted professional opinion, and the relevant view does not need to be universal. However, this peer professional opinion cannot be relied upon if the court considers it irrational or contrary to law, and does not apply to a warning, advice, or other information in relation to the risk of harm to a person. In order for a breach of duty and form to be shown, the plaintiff needs to show injury, loss, or harm, which the law recognizes as compensable damage. Recognizable categories of damage include physical damage, economic loss, psychological damage, and the loss of a chance for a better medical outcome. For the element of causation to be fulfilled, the damage suffered must relate directly to the particular material risk not warned of. The element of causation within the claim of medical negligence is vital for it to be successful. For example, within the breach of failure to warn, a question develops as to what would the plaintiff have done if given the warning. The High Court has applied the traditional approach as where this duty is to inform, is it necessary for the plaintiff to give evidence as to what would or would not have happened if the information in question had been provided. However, due to this being after the event actually occurred, a hindsight bias may form. In order to combat this, a subjective approach is applied as opposed to the objective approach, to ensure a patient's interest in making decisions about their own health and reactive duty to inform has been taken into account. This approach has been adopted under Australian law. Under Section 11 of the Civil Liability Act, a breach of duty caused by particular harm must comprise of factual causation, and the scope of liability must extend to the harm caused. The basic test for factual causation is known as the but-for test and determines whether the negligence was a necessary condition of the harm. The common law threshold test for factual causation has been applied in Adil's Palace Proprietary Limited and Moore Barrack. When deciding factual causation, the matter is to be decided subjectively in light of all relevant circumstances, and any statement made by the person after suffering the harm about he or she is inadmissible, except to the extent, if any, was a statement about his or her interests. In deciding the scope of liability, the court must consider whether or not and why responsibility for the harm should be imposed on the party who was in breach. Although in the occurrence of novus actus interveniens, there is a breach in the chain of legal responsibility which can either be a human action that is properly regarded a voluntary or causally independent event. However, the evidential difficulties may arise as an issue when questioning whether the result would have been different had a breach not occurred. A remoteness test may also be applied to determine if the defendant could have reasonably foreseen this type of damage. A test such as this was raised in Catanac and Melchior regarding the foreseeable costs of raising a child. Prior to 2010, there had been support shown for loss of chance compensation at the Court of Appeal level in 3 Australian jurisdictions. Thus, the High Court addresses the issue and effectively decided against the availability of loss of chance of compensation in Tabit and Gett. In response to a claim of negligence, the defendant is able to raise a defence which may reduce or negate liability if successful. Specific sections of the Civil Liability Act allow for these defences to be raised, such as sections 13, 15, 18, and 19. The defendant may, in some circumstances, also choose to raise a defence of voluntary assumption of risk. It is under the defence that an injury cannot be done to a person who voluntarily assumed the risk of being injured. As mentioned in Imbrie and McNeely, the doctrine of voluntary risk requires proof that the plaintiff freely and voluntarily, with full knowledge of the nature and the extent of the risk implied, agreed to incur it. Section 13 of the Act discusses the meaning of obvious risk when it comes to the defence of voluntary assumption of risk. Section 14 goes on to mention persons suffering harm presumed to be aware of obvious risk, in which the onus is reversed to the plaintiff to rebut awareness of the obvious risk. If the claim in wrongful birth is found to be successful, damages may be awarded to the plaintiff for the injury caused. Damages may come under 2 categories: nominal damages, which can be aggravated or exemplary, or compensatory damages, which can be special damages or general damages. Chapter 3 of the Civil Liability Act particularly focuses on assessment of damages for personal injury and specifies the limitation on granting damages. As one of the most controversial areas of tort law, wrongful birth has developed as an established area of the law in which claims arise out of the birth of children. The leading case for this tort is that of Catanac and Melchior. Upon the facts of the case, Dr. Catanac, a special obstetrician and gynecologist, was found by the trial judge to have been negligent in failing to advise Mrs. Melchior that an operation performed for the purposes of rendering her sterile might not have done so. Mr. and Mrs. Melchior was awarded damages, and that included a modest amount for the cost of raising their 3rd child, who was subsequently born without disability. The majority of the High Court confirmed the availability for the costs of raising a child component of wrongful birth claims. The compensation which required consideration and appeal by the High Court were the expenses associated with rearing and maintaining the child born as a result of a failed sterilisation. The majority of the court strongly confirmed the availability of these damages. In response to this, the Civil Liability Act was amended to include provisions limiting the award of damages for claims of wrongful birth. Section 49A and 49B were inserted into the legislation in late 2003 to prevent claims for costs of economic loss arising from rearing or maintaining a child following a failed sterilisation or contraceptive procedure or advice.
Thanks, Lara, for the briefing on the current state of liability. We'll now cross to Casey Current for the social and policy issues surrounding wrongful birth.
In the latest survey conducted in 2015, it would cost a typical middle-income family $406,000 to raise one child through to university. Nowadays, it seems that people are only interested in lawsuits, and when something like this comes up, people's first thought is, I wonder how much people got for that. But how about we look at these cases from a different view, and instead consider the social effects and policy surrounding it. Instead of thinking how much parents received for their cases, instead consider how much has been lost.
As can be seen, the main contributing factors resulting in the $406,000 is transport and food.
Wrongful birth cases usually arise because the parents are asking to be awarded with financial damages that the child has cost them. The main issues surrounding these cases are not that the couple is expecting. Instead, their concern is what will happen once the pregnancy is brought to term. Hence, it should not have to be morally questioned whether it's justifiable for the parents to admit the non-existence of their child would be better than the child's life. If you were to ask most parents of wrongful birth victims, they would still love their child as much as any Australian parent would. They would see the birth of the child still as a blessing but as a burden at the same time. Increase in wrongful birth cases has raised many ethical questions in communities. People start to question whether a new life, something that is meant to be considered as a blessing, can amount to be damage. These particular cases require the courts to decide what the value of human life is. How morally correct is it for parents to state that their child should have never been born? Should parents be able to decide what the value of their child's life is? Should they be able to stand up in front of the court, in front of their child, and confess that they did not want their child to be born? In the eyes of the community, this is probably the biggest social effect that arises from a wrongful birth case. People worry that the parent admitting to the court that their child shouldn't have been born could raise in that particular child's mental illnesses. In an interview conducted with a child of wrongful birth, we can see that this is not the case.
For me personally, I don't see it as my parents wishing I was never born. I don't feel like my parents have loved me any less. The way I see it, they made a decision to not want any more kids, and when this decision was denied to them through negligence of their doctor, they made the best out of a bad situation.
Has this affected you mentally?
However, the way I see it, if your parents are willing to put in the time and effort to go to court and retrieve some of the money they have used to raise you, then they are loving you, and they have given you a good childhood. Hence, it is most likely that they will use the money that they are awarded to help continue to fund your lifestyle. In my eyes, they're not saying I should have never been born, they're asking for some help to continue to give me the best possible life.
Up there with one of the biggest social effects in relation to wrongful birth cases is that the parents did not choose to abort when they had their options. Some defendants will try to argue that, even if the pregnancy was unplanned, the parents were made aware with enough time to abort but still chose to bring the pregnancy to term, and as a result should not be compensated for this choice. Even though this argument was rejected in the courts, with Law and Sline insisting that there was no legal or moral duty to undergo an abortion or give your child up to adoption if the couple are going to have an unplanned child. However, it still becomes a social issue, as an unwanted pregnancy may lead to an unwanted abortion, with people feeling like they will not be awarded any damages under wrongful birth if they don't have an abortion. This results in a conflict of conscience, as for many mothers who are affected by an unplanned pregnancy would never see having an abortion as an option. When interviewing mothers who are victims of wrongful birth, this was a standout theme, with probably one of the most hitting responses featured now. This particular mother commented on the reasoning behind her not wanting to have any more children, and the burden she was faced when she fell pregnant as a result of a faulty sterilisation process.
It wasn't because I do not love my children. I would love to have more. It's because my husband and I felt that we could not financially give another child the life we wanted for it. To then be told that we cannot recover any costs of raising the child due to the fact that we could not decide to abort is outrageous. Until you have physically been in that position, you do not know what it feels like to have a baby growing inside you, relying on you to nurture it, love it, care for it. I was not prepared to go against my morals and my self-beliefs due to the negligence of my doctor, and I think that it is extremely unfair that I would be asked to do that.
A widely viewed public policy argument is that a court awarding damages for the birth of a healthy child will contradict the public policy in regards to a human life being a blessing. However, this is not sound for many reasons. The argument that the birth of a healthy child is a blessing is saying that the emotional benefits of the birth outweigh the financial burdens placed on the family. However, this may not be the viewpoint for several families, and it is in a couple's right to take several measures to ensure that they could avoid conception to the best of their ability, regardless of whether the child is born healthy or not. It can also be argued that if the birth of a child is considered a blessing, why do families stop conceiving? If the birth of the child would benefit their family, why wouldn't couples continue to conceive well into their childbearing years? There can be a few reasons for why a couple would decide to stop, but a few of the main being that they feel like they can't financially support having a child, or because of health problems or risks. Following on from this, in wrongful birth cases, it is not always the case that the couple chooses to go to term with their pregnancy because they deem the birth of the child to be a blessing. Instead, like mentioned before, the choice to abort or put the child up for adoption may be too morally or emotionally disturbing for the couple.
I am currently sitting here with the Honourable Angela Johnson, the Minister for Women, and Linda Jones, President of Mummy Issues, to get their individual perspectives on the area of wrongful birth. Now Linda, being a mother, what are your perspectives on the issue of wrongful birth?
Look, personally, I think the laws in Queensland are ridiculous. I have 3 children and I am so lucky to have them all. However, if I were in a situation where I was not able to support them, financially or even health-wise, I would be looking into sterilisation process. It is unbelievable that these doctors stuff up, and the stuff-ups result in a baby that they can't be compensated for. Reform to the law needs to happen, even if just the smallest change to the legislation would help the affected families. I believe this is just a step forward in achieving justice.
I completely disagree, Linda. Can you imagine how many people could sue doctors because theirs supposedly did not notify them of the potential risk of taking oral contraceptions, for example? I think that if the laws were to change to achieve justice, as you say, it would actually achieve the complete opposite. It would almost open the metaphorical floodgates. There would be so many claims and lawsuits over frivolous things if changes to the legislation were to occur.
Angela, please try and imagine yourself as a person with limited wealth. You and your partner have next to no money and are surviving week to week on a joint income. You do not have the money to raise a child, therefore you take the extra steps to visit a doctor to get yourself sterilised. Your doctor performs a procedure, which you spend lots of money on to make sure you do not get pregnant. And of course your doctor negligently performs the procedure, resulting in conception. Now you have to raise a child which you specifically stated you did not want and have actually taken action to avoid this happening, but due to a doctor's lack of care, you have a baby that you cannot afford to take care of. Why should the parents not be compensated for having to raise a baby now? And when you say the floodgates of litigation will open, if the doctors are performing the procedures correctly, there shouldn't be an issue.
I understand your opinion, however there are other options and alternatives which can be taken by the parents.
What kind of options are you talking about, Angela?
Other options can include adoption or even abortion if the pregnancy is not actually
Let me guess, you're not a mother yet, are you?
No, not yet.
Of course not. You could never understand not being a mother. We have law and policy makers creating this legislation with no care or consideration as to who this affects.
We're going to leave this segment. Thank you, Linda and Angela, for your opinions. I spoke last week with legal professor and policy reformer Elizabeth Moore about Queensland's laws in terms of reform. Good afternoon, Professor Moore. What are your perspectives on the issue of wrongful birth in terms of reform?
Hi Stacey. I've been watching this topic grow and almost snowball over the years. Personally, I strongly believe that reform needs to happen, and our decision makers need to realise this. I have 2 specific ideas for reform, both of which I believe would benefit all interest groups involved. The laws need to change to reflect and ensure that the goals and aims of tort law are fulfilled. Society is ever changing. Every day our values change. In 5 years, the Australian population grew by about 1.9 million. As the population grows, so too does our diversity. And it is our government representatives' job to speak for our values, views and perspectives. It is hard to do this as society is changing every single day. However, it is their job as to represent the people and change the laws to reflect our views and values. Here's a quick introduction to torts in terms of reform. The primary role of torts is restitution in integrum, a Latin maxim basically meaning restoring the plaintiff to the original position had the tort not occurred. There are a variety of objectives of tort to keep in mind when looking at reform of the law. Promotion of individual responsibility is important in relation to medical negligence. If a doctor is negligent and a wrong does occur, the doctor should be made to right the wrong. As important as this is, with the majority of medical professionals working as public servants, it is not them who actually pay for the wrong, but rather the rest of the state. This is because of vicarious liability, where an employer is liable for their employees. In saying this, doctors are already quite scared of being sued, so changing the laws to make medical professionals 100% liable for their actions could also be wrong. If doctors got even more afraid of being sued, there could be a chance that this would lead to unnecessary actions which could even lead to more issues. Another objective of tort is deterrence. Deterrence in relation to medical negligence is also important as it could produce higher standards of behaviour and change practices to ensure negligent actions are avoided. Corrective justice is also another objective of tort. If someone has suffered harm or damage due to negligent actions, they should be compensated to achieve justice. These objectives are important to remember when determining whether the current wrongful birth laws are adequate and also how to best change them. There are so many different societal changes that can generate need for law reform. Some that are relevant to the tort of wrongful birth are changing social values. Our ideas about gender, children, families have dramatically changed over the years. Changing morality and ethics, what is right, what is wrong, what is ethical. Is it ethical to abort a baby you cannot raise for some reason? And changing technology. I wouldn't be here talking to you if it weren't for advancements in medical technology. The law has to do its best to acknowledge all competing interests and opinions and enforce balance between these different views. Currently, the wrongful birth laws do not balance these competing interests. The law focuses on protecting medical professionals, basically the state, without ensuring the needs of parents are met as well. It is difficult to find a solution that balances competing interests. However, some of the proposals I will get to soon aim to achieve this. There are two different tort theories which relate to the key themes of wrongful birth. The first is corrective justice. Corrective justice is a theory which focuses on the connection between law and morality, where one should be held responsible for the actions and the consequences. I think this theory specifically relates to wrongful birth, as a lot of parents believe that an injustice has been created and therefore they deserve compensation for the wrong that was done to them. The second is feminist legal theory. This directly relates to wrongful birth, with the majority of plaintiffs or victims of wrongful birth being women. It may be argued that the law creates an inequality between the genders, as women and families are not being compensated to raise the children they had as a result of a negligent doctor. So I have two ideas for reform. The first includes reforming current legislation, which is section 49A and 49B. These sections were initially brought in to override the decision made in Katna and Melchior. However, I think these sections need to be altered to better fit all the interest groups involved. Obviously, we don't want to open the floodgates and have a great deal of cases rush in, so there still needs to be some restrictions to litigation. This is the current legislation, and the next one is how I have reformed it. So firstly, changing subsection 2, so the parents obviously can claim for the cost of rearing and maintaining a child. but also including special circumstances for which it is acceptable to claim. I've also, in subsection 4, I've put a cap at about 400,000 because a child generally costs over that, but I think over that could be unnecessary, so I think this is quite an adequate cap. And then this is 49B, the current, and this is the reformed legislation, but it's basically the same as 49A. So the main issue is simply changing the current legislation is a common law system in itself. The system has its advantages, as usually the victims are awarded a much higher compensation amount in comparison to an administrative system. However, it does have large disadvantages. Firstly, the system is very costly. If parents are bringing upon this action because they have no money, then the majority of families will not put in more money to bring about a case when they're trying to save their money to raise their child. Litigation has also been proved to cause stress. Attempting to raise a child during a lawsuit may cause the parents to drop the case or not even attempt it in the first place. Studies have also shown that stress courts are also very formal, providing another reason for parents not to bring an action. Also, this court system is very slow, very time consuming. Obviously, if you're pregnant, there's a very limited time to decide what is the best option for your family. The slow speed of litigation system may also push victims to settle for a much less monetary value than what they could have if they had gone through with the lawsuit. The last point is that courts will, if you're successful, mind you, award you a lump sum of money. This lump sum of money may not cover the long-term costs of raising a child from birth to adulthood. This could be due to many different reasons, including inaccurate predictions. For parents, it might be more beneficial to instead receive payments gradually over time to reflect what would normally be spent on a child and also to reflect the changing circumstances within the family. A more viable solution would be to get rid of the sections of the CLA completely and opt for an administrative no-fault compensation system. If a system of no fault was established, this could cancel out some of the problems discussed with the current state of liability. The system would likely cost victims less, be quicker and easier for claims, cause less stress with the informality of the whole process. If the point of compensation is to address the needs of the injured, a no-fault scheme is the most efficient approach. A system like this would make it easy for parents to put in a claim to retrieve and also obtain money to help raise their child. Although there are issues with this system, as it does not make the individual doctor completely liable to the negligent action, nor does it confirm that the doctor was actually wrong in the first place, but rather it just compensates the victims for that damage that was sustained. In my opinion, families involved in wrongful birth cases are much more driven by retrieving and obtaining money necessary to raise their child, rather than having a doctor admit that they were wrong. If a system of no-fault compensation was introduced, it would mean all parties would be paying into a system, like a big insurance scheme. I believe that both medical professionals and families will benefit from a scheme such as this. Creating a scheme would be expensive to start, but I strongly believe that it will benefit. There are other countries around the world that have no-fault compensation schemes for medical negligence, which is very beneficial to Australia and Queensland in specific, because we can model our scheme off the current international ones and also some of our own schemes that we have not in terms of medical negligence. A no-fault compensation scheme should focus on ensuring the needs of the injured person are met rather than requiring litigation to prove that negligence was involved. In my personal opinion, Stacey, a no-fault compensation scheme is the most efficient and effective way to change the laws to best suit all involved parties. Thanks for having me on Medical Malpractice.
I'm Stacey Primshaw. Thanks for tuning in to Medical Malpractice on your Friday night. Until next time, stay safe and take your duty of care.